It's an interesting question to think about how much a restatement can harmonize across different cultures, where there are very, very strong views. I mean, one of the things about working and writing in the area of children's law, everybody, whether that has anything to do with their professional lives or not, cares a great deal and has strong opinions about the right and wrong way to raise children, to treat children. And that is very informed by culture, by one's own experience, by one's religious convictions. One of the delicacies of a restatement in this area is identifying and protecting our very strong interest in pluralism, which does come out in the cases. Our country's very strong interest in pluralism on the one hand, and our interest in a coherent body of law through the case law. I think the more the underlying justifications, the support for laws and trends in laws can be articulated, the better the hope that there can be uniformity around the areas where it seems pretty clear that there is a direction to move that will serve children's interests.
So the sections that I've been focusing on deal specifically right now with a parent's duty to provide necessary medical care to their children, but I'm also looking at the parent's authority to make medical decisions for their child, sort of this very broad authority. And of course the challenge is that we recognize that parents have a constitutional right to make decisions for their children. We also believe, and the law recognizes, that parents are generally in the best position to make those decisions for their children because they know their children best, they know what their children need. But then we also must protect children. And the most challenging cases have involved parents who have deep religious beliefs that that children do not need conventional medical care, but rather that spiritual treatment will heal them, that is all they need. And sometimes children die. Children suffer dire consequences as a result of their parents' decision to not provide them with conventional medical care. So the hardest part for me of this project is trying to balance the parents' rights to make decisions for their children and determining at what point should the state come in and intervene and make decisions for the child over the parents' objections. And the standard that we are working with is, well, when the child's life, health is at risk, then the state should intervene. And actually, it's not only the child's life, but when the child's physical, emotional, mental health is at risk, then the state has a parent's pater duty to come in and protect that child.
So we're working on a section right now on a parent's privilege to use corporal punishment to discipline a child. And there's a lot of case law on this. In every jurisdiction, it's lawful to at least use reasonable amount of corporal punishment. And there's a whole range of cases. Typically the cases where a parent just spanks the child, on the bottom, on a fully clothed bottom, those don't go to court, but actually some state statutes specify that that's permissible. And then you have all the way up to the egregious cases where it's clearly not a question of discipline, it's a question of abuse of the child. So really this section on corporal punishment goes to this core issue that we're all struggling with, which is that family law is trying to both protect children from harm, but also protect families and respect families, their family privacy, family integrity, because when the state steps in, sometimes the very integrity of the family can be destroyed if you remove a child, and the ultimate sanction for parents is to terminate the parental rights to a child. So a lot is at stake. And this is what the law is trying to do, is protect the child and also protect family integrity. And at the same time, in our country, and this is rooted in the constitutional protection for families, is to respect pluralism. And so there are a lot of different family practices in the United States that many people might not agree with and certainly wouldn't follow for their own families, but the Constitution says so long as you are not crossing a boundary, and this is part of what the restatement is about, is trying to articulate that boundary, parents can raise children as they see fit.
it's a very sort of conventional idea that children's rights and parental rights are in conflict, and when parental rights are protected, we are disserving or disregarding children's interests or children's rights. The view of the reporters, I think, across the board is that parental rights, properly articulated and understood, serve children's interests and are very much in line with children's rights.